Chapter 12, Dearborn, Essentials of New Jersey Real Estate Key Terms. So hopefully you've watched a couple of these before, so you know what we're doing. Say the word. I'm going to tell you what the key term review says. Then, if we need to clarify, tighten it up a little bit, we need to talk about it, we will do that. So I'm going to give you the word. Then we're going to talk about it for a little bit. All right. Actual eviction. Actual eviction. So this is a suit for possession, legal removal of the tenant. Sometimes they call this dispossess proceedings. So this is when a landlord is within their legal rights to sue for possession of the property again. So understand this, that leasehold estates or less than freehold estates, when we're talking about leases, the tenants have an interest in the property that is, again, less than ownership, but they do have an interest in the property that they can come into legal possession of that property. However, once that legal possession has terminated and they refuse to vacate, they can, the landlord is well within their rights to sue for possession, dispossess the property, things of that nature, and that would be referred to as actual eviction. Assignment. Assignment. This is the transfer of primary responsibility for a lease to another party. Now, if we're talking about contract law, just contract law in general, you can assign certain contracts, whether it be real estate contracts, leases. Obviously, in this chapter, we're talking about leases. So the transfer of primary responsibility of a lease to another party. So basically, the lease and or contract, if we're referring to everything, has to allow for there to be assignment, okay? But assignment is the transfer of basically one party's responsibility in that lease or contract to another party. Certified property manager. Certified property manager. This is a designation by the Institute of Real Estate Management. So this is basically a designation. This is additional education that you could go and take as a real estate professional to become a certified property manager. You could just be in the business of property managing and never have this designation. However, if you do decide to further your education, there's a real estate business institute that offers certifications, accreditations, things like that. There's a bunch of different ones where you could put different things after your name, and you could basically show the general public and other real estate professionals that you have furthered your career. In regards to a practical sense, is this something that you should do, shouldn't do? I have alphabet soup at the end of my name. I have designations, accreditations, and all that stuff. Has it gotten me more business? No, I don't think it has. But have I been educated on a lot of different things in the business? And do I know a lot of stuff? And has that helped me in general? Yes. So I think the classes and actually learning is much more important than the actual designation that you would get. But this is a designation that you can get. Constructive eviction. Constructive eviction. This is when the tenant is forced to move because the apartment becomes uninhabitable. So if a landlord does not have heat and cold of winter and you're in Detroit, that would be a constructive eviction. If for some other reason it becomes uninhabitable, okay, the tenant can remove themselves from the property and state that it's because of constructive eviction, and they would not be obligated to the remainder of the lease or any part of the lease potentially, depending on what the circumstances are. But that is not up for a real estate professional to decide. That would be for the landlord and tenant courts to decide. Demise. Demise. And this is a transfer of property by lease. So when you demise a property, okay, you are basically giving your property. So when you devise a property, right, you are transferring via will. Demise a property, you're transferring by lease, by a leasehold estate to someone else. So you're giving someone a leasehold estate. Estate for years. Estate for years. estate for years. This is a lease for a definite period of time. So this is when we're talking about our less than freehold or our leasehold estates, this is one of them. An estate for years is for a definite period of time. It has a beginning and it has an end. Something that people always say, they say, Stu, when does how much notice do you need to give to terminate an estate for years? There is no notice needed. It's a trick question if you ever see that on your test. It has a termination date. There is a definitive period as to when it's going to end. And here's the thing also, don't assume that it is an annual or a lease that is going to end in 1 year because you see the word years. It is simply a definitive period of time. A week-long rental of a property is an estate for years. Okay, a 1 month rental with a beginning and an end is an estate for years. A 6 month rental is an estate for years. Okay, a gross lease. Gross lease. This is a lease under which the landlord pays taxes, insurance, and other expenses. So basically, this is what you would refer to as basically like a standard lease. The landlord is paying taxes, insurance, and other expenses. And what the person is doing is they're paying you a gross amount, right? So whenever basically, if you close your eyes and you go, I want to go rent a condo from someone. Okay, I want to go rent a single family home from someone for a year, something like that. Basically, that would be whatever your typical norm would be. You're probably thinking of a gross lease where the landlord is paying all the general expenses of home ownership, right? Of having a freehold estate interest in that property. And then what happens is there's a gross number that the tenant is paying the landlord. Okay, it's a gross lease. A ground lease. Ground lease. This is a rental of land on which the tenants erect their own buildings. There's several different versions of this. There's some in commercial real estate, there's some in residential real estate. But literally, what it says right there, I'm totally kosher as it can be with that answer, is the rental of land in which the tenants erect their own building. Okay. Hold over tenancy. Hold over tenancy. This is a situation when a tenant remains after the lease period has expired. Okay, and if it's a holdover tenancy, it's typically it's typically not at sufferance. So we'll talk about an at sufferance lease later on. So a holdover tenancy is typically when they remain the period after the lease has expired. So they've come into the property legally. So they had a less than freehold or a leasehold estate. Okay, and then what happens is they're simply a holdover. They're a situation where the tenant is remaining. Maybe they said to the landlord, hey, I'm looking to buy a home and I haven't identified the property yet. So can we stay an extra month, 2 months before we find that home? And the landlord, typically says, yeah, not a problem. Cool. Not a problem at all. Implied warranty of habitability. The implied warranty of habitability. The landlord's responsibility for decent conditions. If they are in breach of the implied warranty of habitability, I think I just like saying the word habitability, then there would be what is called constructive eviction. We've already spoken about that. So this is the landlord's responsibility for decent conditions, for habitable conditions, okay? It is the implied warranty of habitability. That is the responsibility of the landlord. A lease. A lease. A lease. This is an agreement transferring use of real estate for a period of time. Yes, it could be for a periodic time where it renews, or it could be for a set amount of time, like an estate for years. Okay, but a lease or a less than freehold estate or a leasehold estate is an agreement transferring use of real estate for a period of time. Lessee. Lessee. Remember, EE receives, OR gives. That is the tenant. The tenant receives the lease. Okay. Lessor. Lessor. This should be easy. Lessor. OR gives. That's the landlord. Simple. Management agreement. Management agreement. This is a property manager's employment agreement. And that's pretty much it. This is how a property manager is going to be employed by a property owner. Okay, so a property management agreement of some sort is going to be how a property manager would be employed. A net lease. Net lease. This is a lease in which the tenant pays expenses like property taxes, insurance, and so forth. So basically, what happens is it's kind of opposite of a gross lease, where they're going to be paying a lot of the expenses, that you see this mostly in commercial. I won't get into the nuances, minutia of this, but this is a lot of commercial properties that, for tax purposes, for the purposes of the fact that the publicly traded company might not want to own real estate because if they ever had to liquidate, go into bankruptcy, things like that, it is much harder to. I mean, think about retail stores that close. They just shut the doors and then you'll see a vacant property for a while. If they had to then also liquidate real estate assets, that could be a problem when a company is looking to close stores and close locations and then liquidate and become profitable again for investors. So what happens is a lot of those larger companies, they enter into net leases like this, where they're paying a lot of those things, use it as tax write-offs and things like that. And then they're still entering into a lease, and it's good for the landlord because they don't pay any of that stuff. So it's actually really it's a win-win. A percentage lease. A percentage lease. This is a lease in which the landlord shares in gross receipts of tenants because of in tenants' business. Think of a mall, shopping area that over the years has been around for 20, 30 years in your area. And think about has it gotten better or has it not gotten better? It's probably directly in relationship to how successful the stores have been in there. So I know an area by us, there is a shopping mall that is absolutely fantastic and is expanded. It has grown. It has been updated, and that's because it's had a lot of good business. And that's because, and the reason why management has been able to update and do these kinds of things is because they have percentage leases. They are getting a percentage of the business, the gross receipts of the tenant's business. Now that's all nuanced and baked into the lease as far as what skews this, that, and the other, and the minutia of it. However, they are getting a percentage of the gross receipts of the tenant's business on top of what they might get in a gross lease. A periodic estate. A periodic estate. It's one of our less than freehold estates. It's a lease with regular rent payments and no stated ending date. Basically, what happens is also, I need to clarify this. I do need to tighten this up. So there's regular rent payments because there is a period set. There's a period that auto renews, right? Unless you cancel it. So let's say it's a month to month. Okay. Then what happens is you give 1 month notice and you could cancel. However, it auto renews if you just don't because there's no stated end date. Okay, so it just will auto renew. This is traditionally what people would think of as a month-to-month rental. Okay, periodic estate. It could be longer. It could be every 6 months. It could be every 2 months. It could be quarterly. It depends on how it's written. Property manager. Property manager. Property manager. That's a person who looks after another's rental real estate. Okay. So typically you have investors, and property management could look like a bunch of different things. I know down at the Jersey Shore, we sometimes do weekly vacation rentals. Sometimes we do vacancy checks. Sometimes we do other things. So a lot of stuff that property management could get into, but this is a person who looks after another's property. Okay, so basically you'll have investors who will need people to manage their properties for them. And that's what a property manager will do. And they'll typically take a percentage of the lease or on the gross of the lease, or they'll take a flat fee. Sublease, sublease, sublease. That's an agreement giving tenancy to another. Original tenant still responsible. So this is different from an assignment. So you see how at the beginning of the chapter of this video, actually, excuse me, we spoke about assignment. Assignment totally just transfers the responsibility of one party to another. This one, a sublease, basically creates another agreement within an agreement. It's giving tenancy to another. However, the original tenant is still on the hook for that lease. It doesn't alleviate them of any of the responsibilities. Right? Suit for possession. Suit for possession. This is the landlord's actual court action to evict the tenant. So this is going to be what the landlord does to do an actual eviction of the tenant. Okay. Summary proceeding. Summary proceeding. This is another term for dispossess proceeding. So what happens is you're actually getting kind of like a big thing here. So the dispossess proceeding, or the summary proceeding, is the actual proceeding. The court action which leads up to the proceeding is is what we were just talking about as far as the eviction is concerned and all of that. So this is the actual proceeding. A tenancy at sufferance. Tenancy at sufferance. Tenants remaining after the lease term without the landlord's consent. So they come into the property legally. That's always something that I have to clarify. They have legally come into the property, usually with a legal leasehold estate, a legal lease, okay? Then they're remaining after the lease term without the landlord's consent. So they're probably doing an actual eviction, okay? Going through the dispossess proceeding, summary proceeding, all that kind of stuff, okay? And this is typically the reason why, because there's a tenancy at sufferance, and how I remember it is that someone's suffering, and that's always the landlord. Tenancy at will. Tenancy at will. Kind of opposite of a tenancy at sufferance, but this is usually a amicable one. It sometimes could be a holdover tenancy, but and again, these could be synonyms for one another. However, and I want to say that because sometimes people use them interchangeably, because what happens is a tenancy at will is with permission versus a tenancy at sufferance. And a tenancy at will can be terminated by the landlord. Okay, so the landlord basically could say at any time, hey, no, we're done with you staying here being a holdover tenant. And it's over. You're now in sufferance. Okay, so the landlord has that response, has that capability of doing that. Truth in renting. So last one, truth in renting. New Jersey specific, guys. New Jersey specific. Truth in renting is a state requirement in New Jersey that the tenants be notified about their rights. It's basically a booklet that they have to be given. If it is a one or two family home that the landlord is living in, they do not need to be given this. However, and also commercial properties, you do not need to give this in the state of New Jersey. However, every other rental, you would have to give them the truth in renting, which gives the tenants an outline of their rights as a tenant. So, guys, I hope you had a great one, and see you on the next video. Have a great night.